The U.S. Supreme Court ruled this week that the state of Maine violated the U.S. Constitution when it refused to make public funding available for students to attend schools that provide religious instruction. The vote was 6-3. Chief Justice John Roberts wrote the majority opinion. North Carolina has an active lawsuit challenging its Opportunity Scholarship program. It provides public funds for students to attend private schools. Plaintiffs are challenging the program based at least in part on religious objections. Will the latest U.S. Supreme Court ruling have any impact at all on North Carolina's case? Well, joining us to help answer that question is Marie Miller of the Institute for Justice. She represents parents who have intervened to defend the Opportunity Scholarships. Thanks for joining us.
Thanks for having me.
Before we get into comparison and contrast between these cases, just first of all, your reaction to this news that the Supreme Court has ruled against the state of Maine. Your organization, the Institute for Justice, actually worked on that case as well and was, I'm assuming, very pleased with the result.
We are. This is very welcome news out of the Supreme Court. It makes clear that if a state is going to provide a scholarship program, that the state may not discriminate based on the religious character of a school or the fact that it provides religious instruction. So very welcome news out of the Supreme Court.
So that case in Maine and the case in North Carolina, certainly not identical, a lot of different circumstances. As you look at that ruling from Maine, how, if at all, does it apply to what you're working on here in North Carolina?
We do think it affects it. So in Carson versus Makin, Maine had enacted a tuition assistance program for parents in school districts that do not provide a public school for students to attend. And Maine's program would help those parents to pay the tuition of private schools of their choice, but only so long as the chosen schools were non-sectarian. And yesterday, the Supreme Court held that that non-sectarian requirement violates the free exercise clause of the First Amendment. And the court explained that Maine had offered its citizens this benefit of tuition assistance, but had conditioned the availability of that benefit on the religious character of parents' chosen schools. And that condition effectively penalizes the free exercise of religion. So similar to Maine, North Carolina provides its citizens the benefit of a scholarship that can be used at any school that meets certain requirements. But unlike the Maine program, North Carolina's Opportunity Scholarship program does not prohibit parents from using scholarships at religious schools. So what Carson does for this North Carolina lawsuit is make clear that the courts in North Carolina may not invalidate the program simply because it allows parents to use scholarships at schools that are religious or provide religious instruction.
Let's get into some of the areas where there might be some differences, and you could tell me why, if at all, this could present some different circumstances for North Carolina. So the case that we're talking about that was just decided was in the federal court system. The U.S. Supreme Court decided it. Our case, the Opportunity Scholarship case, Kelly versus State of North Carolina, is in the state courts. Does that make much of a difference?
It really doesn't here because the states must abide by the federal constitution. The states cannot do something that would offend the free exercise clause of the First Amendment. And so if the North Carolina courts were to provide some remedy for the plaintiff's claims that offends the federal constitution, that would be an offense to the federal constitution and would not be allowed. So
how about
it really doesn't make much of a difference that this is in state court. The federal law still applies.
How about the fact that basically you have a different type of challenge in the sense that in Maine, the challenge was for people who wanted to use the Maine program and were prevented from doing that. And here in North Carolina, the challenge is actually different. It's the program exists and parents can use the program. And the challenge is coming from people who are saying, look, we can't get into these schools because they are religious, and we think that is a problem. Does that create any differences or any challenges that need to be addressed?
It's a difference, but we end up at the same issue. And so to the extent that the plaintiff's claims would require a remedy that would create this carve out in the Opportunity Scholarship Program that would prohibit schools from participating in the receipt of scholarships because they are religious, that by itself would offend the First Amendment. So essentially, the North Carolina courts cannot make the North Carolina program look like the Maine program did before this ruling. So essentially, we end up at the same place, whether it's a challenge to the Maine program or a challenge to the North Carolina program to make it more like Maine's was.
Now, your argument before the State Court of Appeals took place before this decision came out. Are the judges in the Court of Appeals going to be looking at all at the Maine case, or would that happen later? Because they're actually dealing right now with whether the trial of the case would move forward in front of one judge or a three-judge panel. They don't necessarily have to get into any of the details of how the program works at this point, do they?
I think it is relevant to their current decision. They need to look at what the plaintiff's claims would require the courts to do if the plaintiff's claims were successful. What kind of remedy would need to be provided for those claims? And the Carson decision put some limits on what remedies would be available under the federal Constitution. So it is relevant to the current issue before the Court of Appeals in North Carolina.
In that sense, then, did you see that ruling in the case from the U.S. Supreme Court and say, aha, this is good news for us as we're moving forward?
It's good news. It's not by itself decisive of everything in the case, but it is helpful for parents in North Carolina.
And just as a reminder, at this stage, what's being decided at the Court of Appeals, as I mentioned briefly before, whether this case should move forward before a single trial judge or be moved to a three-judge panel. For people who aren't really followers of the legal process, the constitutional process, why is this something important? Why is it important that the judges at the appeals court level decide this issue in the right way as this case moves forward?
Well, the North Carolina General Assembly has decided that facial challenges to state statutes, should be decided and resolved by three judges instead of just one judge. So one trial court judge may not invalidate a state law on its face by him or herself. It must be done by a three-judge panel. And so that's what's being decided by the North Carolina Court of Appeals right now, deciding whether the challenges that the plaintiffs have lodged against this program are facial and so should go before a three-judge panel instead of a single judge. And it goes toward the kind of remedy that would rectify the alleged problems with the program.
And so at this point, the arguments having been made before the Court of Appeals, now basically all the parties are just waiting to get a ruling from the Court of Appeals to see what happens next in the case.
That's right. Right now, all that we're waiting on is a decision from the Court of Appeals to figure out whether the case will proceed before a single judge or a three-judge panel. Right now, all other matters have been stayed until we receive a decision.
But then as that moves forward, once you get a decision from the Court of Appeals, the decision that was handed down from the U.S. Supreme Court at least gives you a little bit more ammunition for your argument.
It certainly does, especially on the merits of the plaintiff's claims.
Marie Miller is an attorney with the Institute for Justice. She is working with parents who have intervened in this North Carolina case to defend North Carolina's Opportunity Scholarship Program. Thanks so much for joining us.
Thank you.